And the areas of law that we work in are elder abuse. We do preservation of housing, so things like tenants' rights and eviction defense. We help with consumer issues, so debt, scams, fraud, identity theft, etc. We do advanced healthcare directives and powers of attorney. And then we help with public benefits, such as Social Security, though not initial applications for benefits. And we provide these services regardless of income. So for today, we're going to talk about what is elder abuse, and we're going to talk about elder abuse restraining orders. We're going to talk about how to screen clients for signs of elder abuse and what those signs are. We're going to talk about elder abuse restraining orders and what they can and cannot do and how someone applies for one. And we're going to talk about looking at when a restraining order might be appropriate for a client, because they're certainly not appropriate for every client. And then I'm going to end talking about resources in Contra Costa County for survivors of abuse. So before we dive in, there's going to be some acronyms that will crop up in the presentation. The one you might hear, the one we're going to focus on is the EARO. That's the Elder Abuse Restraining Order. And most of these are just variations of other restraining orders. Okay, so today, now I'm going to start by talking about elder independent adult abuse and what this is. So first and most importantly, what does elder mean? So the elder abuse law defines an elder as someone who is 65 years or older. And this is important to keep in mind because a lot of us who work with seniors, we may define who is an elder more broadly. But for the elder abuse statute, if you're not 65 or older, you do not count as an elder, and there will be other types of restraining orders that you can apply for aside from the elder abuse restraining order. If someone is younger than 65, they may qualify as a dependent adult, and I will talk about what that is. A dependent adult is someone who is 18 to 64 years old who has some kind of physical or mental limitation that restricts their ability to carry out normal activities or protect his or her rights. And this is a functional test. It's not linked to any specific diagnosis. Basically, to qualify as a dependent adult, you have to have one or more pretty serious disabilities and or health problems that makes it so that you need help with normal tasks of daily living, such as bathing or feeding yourself or getting dressed. A dependent adult also or the category of dependent adults also includes people who live in as an inpatient in a 24-hour health facility. But it can also include people who live independently. And if you're not sure if someone might qualify as a dependent adult, you can always consult an attorney. Contra Costa Senior Legal Services can advise on this. And disabilities that can make someone qualify can include both physical or mental or cognitive disabilities or other health problems. So this is a determination that's made on a case-by-case basis. So now let's think about, can anyone think of some things that make our elders or dependent adults vulnerable to abuse?
Income, I was going to say financial circumstances.
Yeah, definitely. That can be a big factor for a lot of people, and a stressor in the home, which can maybe make someone more likely to be abusive.
Dementia.
Definitely. That's a big one, especially for our seniors. So some of the things that can make the factors that can make our elders and dependent adults more vulnerable include having a disability. I've seen people who caregiver is abusive towards them and they're reluctant to seek help, and they're remaining in this abusive situation because they feel like having an abusive caregiver is better than having no caregiver. And so they're really vulnerable to the abuse just because they don't know who else will take care of them, and they're staying with their abuser. Loneliness is a big one for elders. A lot of people are more likely to fall victim to a scam if they are lonely. This is partly because they might be more open to talking to the scammers who call them up, which definitely opens them up to being scammed. A lot of adults are fearful. They might think that there's nothing that can be done to rectify past abuse, and they fear retaliation, or they're fearful that they won't be believed. A lot of people also fear having their independence taken away, and having others take more control over their lives, their finances. So this desire for independence can also make people more vulnerable because it makes it harder for them to speak up. A lot of people remain silent about abuse to protect abusive family members from the legal consequences of what those family members have done. A lot of people are also just too embarrassed to admit that they have experienced elder abuse. I know this is definitely the case with certain forms of financial abuse like scams. A lot of people are really embarrassed about being scammed, and they feel like it's their fault. And so they don't say anything. And if abuse is extreme or prolonged, the elder may actually have begun identifying with the abuser, which also makes them vulnerable to continued abuse. And when people are isolated, it also makes them more vulnerable because there are fewer people in their lives who can notice the abuse and provide support and help the elder get the help that they need to leave the abusive situation. I want to talk a little bit about capacity, because for those of us who work with elders or dependent adults, this is really important. Some of the people that we work with may not have the ability to make decisions for themselves. Sometimes seniors have some cognitive impairments, but they still may retain the basic ability to ask for help. And capacity can be really tricky to evaluate because depending on what it is the person wants to do, capacity can vary. Like you might have the capacity to ask for help with getting a landlord to return your security deposit, but you may not have the capacity to execute an important document like a power of attorney. And capacity can also vary. Some seniors might have capacity in the morning, but not in the evening, depending on their situation. Some of the signs that capacity might be an issue are if you have a client who's calling you multiple times a day or week or a month, and not remembering your previous conversations, not remembering that they've talked to you before. If someone has trouble telling you basic details of their lives, such as what's their address or their date of birth, that's a sign that maybe there are capacity issues there that you should be aware of. And also, if someone doesn't know why they're there to see you, you should really flag that as maybe a capacity issue. And if a client doesn't have capacity, unfortunately, my organization, Senior Legal Services, usually can't take them on as a client, but we make that determination on a case-by-case basis. And capacity issues that come up for our elderly population are one of the reasons why it can be good for seniors to set up a power of attorney. So they have someone to help them maybe apply for a restraining order down the line once they lack or have lost capacity. So Who experiences elder abuse? Seniors across all socioeconomic groups, cultures, races, religions, all backgrounds experience elder abuse. Women are more likely to be affected by elder abuse. And elders who lack capacity, such as have dementia, like someone mentioned earlier, they are more vulnerable to elder abuse. And the incidences of elder abuse are really high. I've heard estimates that as much as 1 in 10 Americans age 60 and older have experienced elder abuse. So now I want to talk about what constitutes abuse of an elder or dependent adult. And there are different forms of elder abuse. One of those is physical abuse. And physical abuse includes an unreasonable physical constraint, such as tying someone to a chair or strapping someone into bed when this isn't necessary for the person's safety. It can include prolonged or continued deprivation of food or water. It can include medication misuse, which is the over-medicating or administering of drugs for a purpose that isn't authorized by a physician, such as a punishment or a restraint. We may have heard about this in the context of long-term care facilities where people might be given medications just to sedate them and keep them in place and not have them cause problems for the facility. Physical abuse can also include what we just might classically think of as physical abuse, such as hitting someone or pushing someone or pulling someone's hair. Another type of abuse includes sexual abuse. And this is essentially any type of non-consensual sexual activity. Another form of elder abuse is mental or emotional abuse. And this can include harassment and intimidation that causes emotional distress, fear, such as maybe name calling or threats to put someone in a home. Isolation of an elder is also a form of elder abuse. And this is a tool that's used by many abusers, and with the systematic exclusion of all outside contact, the elder victim can be driven to distrust friends, doctors, and even close family. And ultimately, the elder can become a pawn for the abuser. Another form of elder abuse includes deprivation by a care custodian or caregiver of services or things that the elder needs to avoid harm or suffering. So this can be, an elder has a caregiver and the caregiver isn't taking care of the elder. The caregiver isn't feeding the elder or taking them to the doctor or making sure they get their medication. Elder abuse also includes neglect or abandonment. And then there's this catch-all part of the definition, which is any other treatment that results in physical harm, pain, or mental suffering. And I'll mention that when we say goods or services necessary to avoid physical harm or mental suffering, this can include, but isn't limited to, medical and mental health care, assistance in personal hygiene, adequate clothing and shelter, protection from health and safety hazards, protection from malnutrition, and the transportation and assistance necessary to secure any of these needs. Another form of elder abuse is financial abuse. And this is defined as happening when a person takes the property of an elder or dependent adult for a wrongful use or with intent to defraud, or if someone helps with any of the above, if the person who's doing this knew or should have known that this conduct would likely be harmful to the elder or dependent adult. And put more simply, financial abuse is really just the wrongful taking or use of an elder's funds, property, or other assets. And financial abuse is actually one of the most common or the most common forms of abuse that's reported to the Contra Costa County Adult Protective Services. And financial abuse can be a little tricky because it can be difficult to establish that's the intent, to be difficult to establish that someone intended to commit this financial abuse. For example, you have an elder who gives her son and daughter-in-law $20,000 to help the son and daughter-in-law with financial challenges, on the understanding that the elder would be moving in with the son and daughter-in-law and they would take care of the elder. And now the elder's in hospice and the family said, oh, we can't care for you any longer or afford to repay you. And maybe this money wasn't explicitly designated as a loan. You know, you might wonder, is this financial abuse? Can you really show that the son and daughter-in-law intended to trick the elder out of her money? Or is this just a case where the son and daughter-in-law are now overwhelmed by the realities of caring for their dying family member? So financial abuse can be harder to establish. However, some examples of financial abuse include scams. Scams are a huge one. So if a scammer convinces a senior to wire money to a foreign country for an investment, that would be considered financial abuse. Or if a daughter agrees to help her mother pay bills, but then the daughter writes checks to herself from the mom's account without the mom's permission. Or if a new friend gets a senior social security number and opens up credit cards in the senior's name, that would be an example of financial abuse. And then lastly, a financial advisor who asks a senior to invest in their side business, and the side business turns out to be fake. These are all examples of financial abuse. And as I mentioned, scams are financial abuse. We should all know the signs of a scam. These include pressure to pay today or the offer will end, threats that someone will be arrested, asking for payment via wire transfer or gift cards. If names and emails are slightly changed or things look off, that can be a sign of a scam. And also just if something feels off, you should trust your gut. Prevention is the best weapon against scams. And this is because if someone is scammed, it can be really difficult to impossible to recover the money. And unfortunately, a restraining order probably isn't going to help with a scam because often people have no idea who it was who scammed them or where that person is. And to get a restraining order, you need to know who the other person is and where you can find that person. So elder abuse is very common in Contra Costa County, as it is in most places. During 2022, there were over 6,200 elder abuse allegations made to Adult Protective Services, and financial exploitation was the most common allegation, with over 1,300 allegations. Other allegations that were common were neglect, psychological or mental abuse. Oh, I'm sorry, I see I put neglect on there twice with different numbers. My apologies. But the point is, elder abuse is really common in our county. So chances are we might all know someone who has experienced or is experiencing elder abuse. So it's really good to be aware of this when dealing with seniors, that they may be experiencing elder abuse. And if you have a friend or know someone who might be experiencing abuse, we should reach out and offer help to that person. So who are the people who commit elder abuse? Family members commit elder abuse, and this is a huge one. I would say in most of the elder abuse cases that I deal with, it is a family member who is abusing the elder. This can be adult children, siblings, grandchildren, maybe a spouse. Caregivers also commit elder abuse, as do friends, people who befriend an elder and pretend to be that person's friend for the purpose of taking advantage of the senior. Also, unfortunately, lawyers and financial advisors commit elder abuse. And then another huge category are strangers and scam artists. Now I want to talk about the signs of elder abuse. And it's good to be able to recognize these signs so that if we see these signs in the seniors we're working with or a friend, we can make sure to check in with that person and offer support. So some of the signs of elder abuse include if someone stops participating in activities that the elder once enjoyed, if an elder looks messy or unkempt, like they're not being cared for, if someone has trouble sleeping, if someone has unexplained weight loss, if someone becomes withdrawn or acts agitated or violent, displaying the signs of trauma, such as rocking back and forth, or if someone has unexplained injuries, such as bruises or burns or other injuries. Also, if someone has broken eyeglasses or eyeglass frames or shows some sign of punishment or restraint in the context of long-term care facilities or people who are bedbound, if that person develops bed sores or some other preventable condition, maybe that's a sign the person is being neglected. If someone lacks the medical aids that they need, like glasses or a hearing aid or medication, or maybe a walker. If someone's living in hazardous or unclean or unsafe living conditions, like maybe their power is off and they're living in the dark, or there are rodents in their house. If someone is receiving an eviction notice for unpaid rent, or notice that their mortgage payment is late, or they're being evicted from their home, this can be a sign of elder abuse, including financial abuse. Also, if someone shows signs of insufficient care or unpaid bills, despite the fact that they should have adequate financial resources, that can be a sign of elder abuse, including financial abuse. So some of us may be mandated reporters, and they're required to report a reasonable suspicion by phone immediately and in writing within 2 working days if they suspect elder abuse. And I'll note that attorneys are not mandated reporters because we have attorney-client confidentiality, and we're required to not tell anyone about the abuse unless we get permission from the senior. So now I want to share a scenario that we can all talk about. So Mary is a 75-year-old woman who lives with her daughter, Catherine. And Mary is in a wheelchair and she cannot dress or bathe without help. She relies on Catherine to take care of her. And when you speak to Mary alone, she tells you that Catherine yells at her when she's frustrated, but Mary relies on Catherine for help. And Catherine tells you that Mary doesn't know what's going on, but you see that in your own communications with Mary, that Mary's able to communicate with you pretty easily. Does anyone see any signs of abuse here in this scenario? Feel free to jump in.
We have one person in chat saying yelling equals verbal abuse.
Yes, definitely. That could fall in the category of mental abuse.
And then a few other people saying emotional abuse in chat.
Definitely. And when we have Catherine telling us that Mary doesn't know what's going on, that might be a warning sign of abuse. Maybe Catherine is trying to prevent Mary from seeking help.
And also the fact that Mary can communicate pretty easily.
Definitely. And you know, Mary, we see based on Mary's situation that she does have some vulnerabilities here. She is in a wheelchair, she relies on her caregiver. And that can definitely make someone more vulnerable.
And then just a few more
Oh,
that
yeah, go ahead.
they said that Mary is dependent on Catherine, so she may be fearful. And that, you know, there's a difference in the story between the caregivers and the client.
Definitely. Does anyone see capacity issues here?
One person says no.
Yeah, it seems like based on our own conversation with Mary, she's able to communicate with us pretty easily and isn't having trouble expressing herself. And I'll mention this because this is one of the reasons why those of us who work with seniors, why it's really important that we have the chance to talk to the senior alone without others present. Because it's really important that we be able to speak with the senior privately and be able to get a clearer picture of what's actually going on with the senior and what is their situation. Because we might hear different things from the senior and from the other people in their life. So now I want to talk about elder abuse restraining orders. And these are a type of restraining order that is for elders, so people who are 65 and older, and dependent adults. And so I want to talk about what is required for an elder abuse restraining order. And so first, the person who wants the restraining order, they're called the petitioner. They have to tell the court, usually through a written statement or what we call a declaration, that the person they want restrained, this is their abuser, known as the respondent, that they have to tell the court that the respondent, the person they want restrained, has committed an act or acts of elder abuse. And an order can be issued with or without notice to restrain any person for the purpose of preventing a recurrence of abuse, as long as you show reasonable proof that elder abuse has occurred. And when I say with or without notice, this just refers to the ability of a person to get a temporary restraining order before they've given the other person, the abuser, notice that they're applying for the restraining order and before a hearing has happened. And so even if a request for an initial temporary restraining order is denied at a later hearing where someone goes to see the judge, this hearing will usually be 2 or 3 weeks later, and they'll still have a chance to get a restraining order at the hearing. And in this application, this initial restraining order application, the petitioner, the person applying for the restraining order, they're under the penalty of perjury. And so it's good to get all the facts in at this initial application stage so that the judge has them in front of her. And when I say that, you want to provide facts of what the abuse is and what's been going on, so that the judge can see, oh yes, this person has been experiencing elder abuse. And who can file for an elder abuse restraining order? So an elder or a dependent adult can apply for a restraining order for themselves. A guardian ad litem or a conservator, if someone is conserved, can apply for a restraining order on behalf of another. Someone's attorney, in fact, can apply for a restraining order. And an attorney, in fact, is a person to whom an elder has given a power of attorney. So if an elder sets up a power of attorney and names their daughter as their attorney, in fact, then the daughter can apply for a restraining order on the mom's behalf, assuming that the elder allowed the daughter to do this in the power of attorney. Adult Protective Services can apply for a restraining order on behalf of an elder or dependent adult if the elder or dependent adult gives written authorization, or if the elder's ability to comprehend the risk of harm is impaired. And this is really rare. And then the statute also just has a catch-all saying that others with legal authorization may apply for an elder abuse restraining order on someone else's behalf. So applying for an elder abuse restraining order can have some advantages. It can be used to protect people who lack capacity. So for instance, if you have an elder who lacks capacity, but they set up a power of attorney, then the person who they gave the power of attorney to and made their attorney, in fact, that person can apply for a restraining order for the senior. An elder abuse restraining order can eventually be made permanent at the renewal stage. So the restraining order will last forever. And then protection is available in cases where the abuse is exclusively financial abuse. And unlike with a domestic violence restraining order, that's another type of restraining order. With an elder abuse restraining order, there is no relationship requirement. So it doesn't matter what the elder's relationship with the abuser is, as long as the elder is 65 or older, or they're a dependent adult, they can apply for the elder abuse restraining order. And then an elder abuse restraining order can be better for clients than another type of restraining order called a civil harassment restraining order. And this is because the elder abuse restraining order has a lower, what we call burden of proof. And the burden of proof is just the level of proof that the person applying for the restraining order has to meet. So basically how convincing they have to be with their evidence in court when they go to court. And an elder abuse restraining order is also designed to be flexible. So the elder can ask for, different types of orders depending on whatever it is that they want. And there's a lot of flexibility there. Some of the disadvantages of an elder abuse restraining order can be that there aren't as many available orders in an elder abuse restraining order as there are in a domestic violence restraining order. And a domestic violence restraining order is something that you can get typically against a family member or a romantic partner. And there are more orders available in those domestic violence restraining orders, especially if both parties are married. One of the weaknesses of an elder abuse restraining order is that it's not a tool to use to recover money, with the exception maybe of a debt that was caused by the abuse. Also, as with any restraining order, it can be hard to enforce elder abuse restraining orders. They're not perfect magic tools that all of a sudden transform an abuser into a nice person. And depending on the circumstances, enforcement can be really tough. especially in the case where the parties have to continue to live together after one party gets a restraining order against the other party, and where the elder isn't able to get an order that the abuser move out. And so just quick to compare domestic violence restraining orders and elder abuse restraining orders. A domestic violence restraining order and elder abuse restraining order, they're both civil orders, so they're not part of the criminal justice process. But the domestic violence restraining order is something you get in family court. And there's a different law that deals with domestic violence restraining orders than elder abuse restraining orders. But they both have the similar burden of proof and very similar procedures. And there is some overlap in the orders that are available, such as an order that someone stay away from another person. And then there's also different forms that you would use. So now we're going to talk about what can a restraining order do for seniors. And these are going to be orders that an elder or dependent adult can obtain in an elder abuse restraining order. So the first category of orders available are stay away orders. And this is where the restrained party is ordered not to come within a certain distance of the elder or dependent adult, any other protected parties that have been added, the elder's or dependent adult's home or job or workplace, vehicle, or other locations that maybe the elder or dependent adult often goes to. And this can get complicated when the parties live together, but there's no move out order. And so the parties are going to continue to live together. So you might wonder, how does the stay away order work in that context? Typically, it's a very short stay away order. Like the abuser might be ordered to stay 6 feet away from the elder or dependent adult. And this can also be tricky when the parties live on the same property or in the same apartment complex. Another type of available order, and this is one that a lot of people are very interested in, is called a move out order, also known as a residence exclusion. And for a temporary restraining order, to get a move out order, you have to show evidence that the elder has a right to possession of the premises, that the party that's being excluded, that's being ordered to move out, has assaulted or threatens to assault the petitioner, or some other family or household member or conservator, and that physical or emotional harm would otherwise result. And there can, some of the complications with a move out order can be that if the respondent, if the abuser is ordered to move out, they often have no time to pack up their belongings. If the sheriff is coming to kick them out, the sheriff will just show up and say, okay, you're leaving. And the elder might be left with a mess to pack up. This is actually a big concern with a lot of elders, is what do I do with the abuser's belongings once the abuser has moved out? And we may want to advise the elder to arrange pickup of the abuser's belongings through a third party to help the elder deal with the situation. Also, a lot of elders, they really feel guilty about getting a move out order against a family member. I have a lot of clients who are applying for restraining orders against adult children, and they worry that getting a move out order against their adult child will leave the adult child homeless. And this is really difficult for a lot of people. And so those of us who are working with elders, we're going to need to be aware of this and help our clients process the feelings of guilt that they have, focus on the choices or lack of choices the elder might have when their health and safety is at stake. So Some other important points are, when I say the elder's right to possession of the property, I mean that the elder must have an equal or greater right to live in the home. And so, one example where an elder doesn't have an equal or greater right to live in the home, where they're not going to be able to get the move out order, is where you have an elder renting a room in a house and the landlord lives in that house as well, and the elder is being abused by the landlord. The elder is not going to be able to get a move out order against the landlord because the landlord is the owner of the home and the elder is just renting a room. And the title or lease to the residence must not be in the name of the respondent only, or the respondent or a third party. So not everybody will be eligible for a move out order depending on their living situation. And then also there's more leeway for a judge to order a move out order after we've had the hearing. Physical abuse and a threat of physical abuse are not required to get a move out order after notice and a hearing. So for example, a person who is suffering financial abuse, they may not be able to get the move out order in the temporary restraining order, but they may be able to get one in the final restraining order that's issued by a judge at the hearing. I will mention, however, that oftentimes, despite what the law says, judges do not like to order someone to move out if there hasn't been physical abuse or a threat of physical abuse. That's not to say that a judge can't order someone to move out where there hasn't been any sort of physical abuse or threat of physical abuse, but it's harder to get the judge to agree to order someone to move out. And judges often don't like to do that. The judges don't like to make someone homeless unless they really feel like it's necessary for the elder's safety. One more limitation that I'll mention with move out orders is that the law limits move out orders to parties who live in the same dwelling. And this means the same apartment unit or home. So if the parties live in different units on the same property, a move out order will not be an option. So if you have an elder who lives in a house and an abuser who lives in a backyard unit, the move out order is not going to be something that the elder can get. So now let's check our knowledge. If we have a woman who calls and says her nephew is abusing her and she wants a restraining order, she's over 65 and her nephew lives in the house with her that she has owned for 20 years. Based on this, can she exclude him?
Oh, Susan said, oh, a lot of people are saying yes.
Yes, good job. That's correct. She owns the home, and so she's eligible for the move out order based on that. Of course, it'll depend on the facts of the abuse, but we won't get into that. Oh, sorry. Now, the woman tells you that 5 years ago, she put her nephew on the title to her house with her, and now she wants to take him off. Can she exclude him?
And now a bunch of no's.
A bunch of those. So I'm going to say to this one, yes, because they are now co-owners, so they have an equal right to the home. However, because the nephew is now a co-owner of the home, he can force the sale of the house if he wants to. And then bonus question, can she take him off the title? And this isn't something that I strictly covered, but it is something that comes up with our seniors.
Well, a lot of people are saying yes. Some people say no, but 3 yeses.
So I'm going to give an uncertain answer and say probably not without litigation, but maybe she can if he agrees to this. So other available orders include what we call personal conduct orders, and this includes an order of no abuse, and where the restrained party is ordered not to physically abuse, financially abuse, intimidate, molest, assault, attack, stalk, threaten, harass, destroy the personal property of, or disturb the peace of the protected person. It can also, a personal conduct order can also include a no conduct order, and this includes both direct contact and indirect contact. So indirect contact would mean contact through a third party. And then a restraining order an elder abuse restraining order can also include just any other orders that are needed to protect the petitioner from harmful or abusive behavior. So here's a scenario. Paul is 85 and lives in his home alone. He's a generous person and a beloved member of his family and community. Dave, Paul's ex-wife's son, asks Paul if Dave can move in when Dave needs a place to live, and Paul says yes, because he's a nice guy. A few months later, Paul's friend asks if a relative, Sheila, can also move into Paul's in-law unit because Sheila needs a place to stay. Dave and Sheila start dating. Sheila gets very paranoid and starts yelling at Paul. And when Paul asks her to move out, she stands over him in his chair, grabs his remote, yells at him that she will kill himself if he kicks her out. Later, Dave corners Paul in the bathroom and tells him that if Sheila hurts him or hurts herself, it would be Paul's fault. Paul is intimidated by Dave and Sheila, and he wants them to move out. Do we think that Paul could file a restraining order here? What kinds of abuse do we see here?
We have one person saying yes, physical, emotional, fear and intimidation. Susan saying yes, intimidation. One people are saying physical, verbal, intimidation.
Yeah, definitely. I would say all of those seem present here. And can anyone think of maybe any other services that we would want to offer Paul?
One person did say yes to an RO.
Yeah. I think we could discuss restraining orders with Paul and see if that's something he's interested in.
An RO with a move out order.
Yeah. We could certainly ask for a move out order. And it'll be up to the judge what the judge thinks. So to apply for an elder abuse restraining order, there are multiple steps in the process. The first step is you complete a set of elder abuse restraining order application forms, and you submit these forms to the court in Martinez. These have to be submitted in person, and these go to the main civil courthouse in Martinez any Monday through Friday between 9 and 10:30 in the morning. And then I'm talking about Contra Costa County here. Every county will have a different process for this. So if you're working in another county, it's best to go to that court's website or call the court for information on how to apply for this restraining order. And so then you submit the forms, then a judge looks at the forms, and then someone from the court calls you when the forms are ready and tells you to come and pick them up. Then you go to the court, you pick up the forms, and then the next step is you have to have the respondent, the abuser, served with one copy of the documents that you filed, plus a blank response form. At least these have to be served at least 5 days before the hearing. So when I talk about giving notice to the abuser of the restraining order application, this is what I'm talking about. We give the abuser notice by serving them, meaning just giving them a copy of the restraining order application form and this form for the abuser to respond. And then the next step is the elder or dependent adult, the petitioner, has to appear at a hearing. And it's at this hearing where the elder or dependent adult goes, sees the judge, and they can present evidence of the abuse, and the judge there decides whether the elder should get the restraining order and what the restraining order should do. And for those who live in Contra Costa County, the court branch that you have to go to for the hearing will depend on where the petitioner lives. And then the last step is if the judge says, yes, you can get a restraining order, I'm giving you a restraining order, then the petitioner may have to serve the final restraining order, meaning give the other party a copy of the final restraining order. And I'll mention one question that I hear a lot is, does the abuser have to come to the hearing? And the answer to that is no. The abuser does not have to appear at the hearing. They can be there if they want to, but they do not have to be there for the elder to get the restraining order. So there's a few different forms that someone needs to fill out and submit to the court to apply for this restraining order. And these forms are used statewide. So whatever California county you live in, it will be these same forms that you must use to apply for the restraining order. These are a form where the EA 100 form where you say what you want the restraining order to do and give information about why you need the restraining order. There's a form where the court will give notice of the court hearing. That's the EA 109. And this is the form where the judge will write the date and time of someone's court hearing and the location. And then the other form is number EA 110, and this form actually becomes the person's temporary restraining order, assuming that the judge grants a temporary restraining order. And these forms are all available online for anyone who needs them. I'll also mention that the family court in Contra Costa County will give out all of these forms to people for free. Briefly, the restraining order process is step one. You have to submit these forms to the court, as I mentioned, and pick them up. And the judge, when they're reviewing their forms after you submitted them, will either give you a temporary restraining order or deny it. And tell you when your hearing date and time is. And usually the hearing is about 3 weeks after you first apply for the restraining order. So it's a quick process. And you can get that temporary restraining order, right away after you first apply for the restraining order. The next step, as I mentioned, is you have to serve the abuser with the restraining order. And this has to be personal service. And what I mean by that is someone actually has to give the abuser a copy of all the required paperwork. They can't just post it at the door of the abuser's home or send it in the mail. And the person who serves the paperwork can be any adult age 18 years or older, who is not a party to the case. So it cannot be the elder who serves their own restraining order. And service typically has to happen at least 5 days before the hearing. And this can be really hard for people if they don't know where their abuser is, particularly where the abuser may be transient and not have a permanent home address. And whoever serves the paperwork has to fill out something called a proof of service. And this is just a form that says, yes, I served such and such a paperwork at this time on this date. And then this proof of service gets given to the court. So the judge knows that service happened and the judge knows that they can proceed with the restraining order case, and the judge can make a decision on whether to grant or deny the restraining order request. The sheriff can serve restraining order paperwork for free. So I often think this is a good idea for people, especially if someone's being kicked out of the house. The sheriff is a good option because the sheriff will show up and kick them out for you. The responding party, that's the abuser, they can file a response to the restraining order application that the elder has filed, but they're not required to do this. As I mentioned, serving a restraining order can sometimes be the hardest part of the restraining order process, because it happens that people have no idea where they can find the abuser. And so if you're working with someone where this is an issue, there are some things you can do to try to find the person. You can just look online, go to Google, go to Facebook, and see what you can learn about this person. Maybe learn about where they work, and you can serve them at work. You can also search court records and see if maybe this person has a court date coming up, and you can show up at court and then serve them at court. You can try talking to someone's former coworkers. They may be more willing to disclose information about the whereabouts of the abuser than family members would be. And you can try sending mail return service requested to the abuser. So you can write an envelope with the abuser's name and return service requested on the envelope. And then the post office will return the envelope with the person's address, or give a reason for not including it. So you can try that. And then finally, if everything's been served, you have your hearing, and the judge can proceed with the hearing only if personal service was completed. If you haven't served the person, then the elder still needs to go to court. And all that will happen is the judge will continue the hearing, meaning just postpone the hearing date for the hearing for a later date. And this will give the petitioner more time to serve the restraining order. And the judge will also reissue the temporary restraining order. So the petitioner, the elder, will continue to be protected when the hearing is postponed. And at the hearing, the petitioner has to be ready to argue their case. They can bring evidence of the abuse, such as a photograph of their injuries, to show the judge. They can bring witnesses. So a good witness is someone who saw the abuse happening with their own eyes or heard it happening. And I'll mention that many people don't have attorneys at these elder abuse restraining order hearings. And I'll also note that the respondent is entitled to one continuance. So this means that the respondent may ask one time to have the hearing postponed to a later date. And this is to give the respondent more time to prepare their case, time to respond to the petition, time to hire an attorney if they want to. And so if the person who requested the restraining order, so the elder dependent adult, does not show up at their hearing date, then the temporary restraining order will expire that day and the case will be dismissed. So it's really important that people appear for their hearing dates if they still want the restraining order. In Contra Costa County, we also have free mediation that's available at the court, and mediation is just where the parties go and negotiate outside the courtroom and see if they can come up with some other agreement as an alternative to getting the restraining order and having the hearing. An elder abuse restraining order can last for up to 5 years. And I mentioned something earlier about the burden of proof. So the burden of proof for an elder abuse restraining order is what we call a preponderance of the evidence. And all this means is that the elder or dependent adult has to prove to the judge that it's more likely than not that the abuse has actually happened. So sometimes we might hear people, there is no numerical value to this, but we might hear people say that they have to prove that there's a 51% chance or more that the abuse actually happened. And it's the person who applied for the restraining order that has to prove that the abuse has happened. So a restraining order can be renewed, and you want to request this renewal within 3 months before the date of the expiration of your restraining order. Or you can request it anytime within 3 months before your restraining order expires. You don't need to show that any new abuse has happened since you got the restraining order. And it's at this renewal, it's as part of this restraining order renewal that your restraining order can actually be made permanent. And it's really important to keep in mind that once a restraining order has expired, no renewal is possible. So you cannot renew your restraining order if it's already expired. And if that person wants a restraining order, then they're going to have to submit a whole new application for an elder abuse restraining order. And they're going to have to show evidence that new abuse has happened or that there's some ongoing risk of harm. So it's really important that if someone wants their restraining order to continue to be in place, that we help them renew it before it expires. So one scenario here, Lucia is 68 and lives with her husband who has dementia and her adult son. Lucia is a monolingual Spanish speaker. One day, her son brings over a woman named Sharon, who says she's homeless and has 4 kids. Lucia very nicely agrees to let Sharon and her kids stay for a couple weeks until they get back on their feet. However, Sharon and her kids end up staying for months and will not leave. Sharon uses drugs regularly and goes on tirades and yells at everyone in the house. Lucia's husband is very disturbed by Sharon's yelling, and Lucia finds needles in the bathroom and cleans them up. Sharon often will leave for days at a time and doesn't feed her kids enough. Lucia pays for food for the kids, even though Lucia doesn't even have enough money for herself, and Lucia falls behind on rent. Sharon also yells at Lucia, but Lucia doesn't always understand exactly what Sharon's saying because Lucia doesn't speak English. Do we think Lucia may be able to file for a restraining order? What forms of abuse do we see here?
One person says yes for restraining orders. They can just go to the nearest sheriff's office. One person says emotional, or yes for emotional and financial. Another one says yes for emotional, financial, and then the legal drugs portion too. So a lot of people are saying emotional and financial.
Okay. Yeah, so definitely emotional abuse. Financial abuse, I think, would be a little trickier here because we would have to establish that Sharon was intending to wrongfully take Lucia's money or property. I'll say that I've also seen in elder abuse restraining order cases, in instances where an elder is left caring for children that they really can't care for. That can be a reason to get a restraining order. So that's also something that we could point to in a restraining order application, the fact that Sharon's leaving her kids with Lucia. Can we think of any other services that we might want to offer Lucia?
One person did bring up CPS for neglect of the children.
Yes, I think we could definitely advise Lucia to make a CPS report or get permission to make that report for Lucia.
Yeah, just a few more with restraining orders and move out.
Yeah, we might also want to offer Lucia food assistance. If she's food insecure, we might want to offer her help her connect her with rental assistance if that's available. If Lucia gets word that she's being evicted, we could offer her additional legal assistance to help with the eviction. So yeah, there's all kinds of services that we could offer here. So next, I want to talk about restraining order enforcement. The way to enforce a restraining order is that the person who is protected can call the police if the restrained person violates the restraining order, and the police can come and arrest the restrained person for the violation. However, police responses will vary by city, and the way the police respond may also vary depending on the violation that's occurring. So the police might respond differently if the violation is showing up at the elder's home versus just calling the elder on the phone. I'll also mention that because it is the police who are charged with enforcing restraining orders, not everybody may be comfortable calling the police to enforce a restraining order. So if we are working with someone and discussing restraining orders, it's really important that we tell them how restraining orders are enforced, that it's the police who do this, and make sure that the senior is going to be comfortable calling the police. And if they're not comfortable calling the police, then a restraining order may not be a good option for them. And we might want to talk about other ways to keep them safe. Protected people can also go back to court for contempt if they document the violations and make police reports. And then the restrained person may have to pay a fine, but this is really uncommon, I would say. So now let's troubleshoot some scenarios. If we have a client who comes to us and says, I need a restraining order against an acquaintance, he came to my house and threatened to kill me, I don't know what to do because he has dementia and now I don't know where he is. What do we think about this scenario? Are there any issues that we see arising here? Any problems?
One person says finding him.
Yeah. If you don't know where he is, it can really be hard to serve the restraining order, and you may not be able to get the restraining order.
Yep, just more people saying that it would be difficult to serve an RO without knowing where he is.
Yeah, I would also mention that the fact that the abuser has dementia might also make things a little tricky, including in terms of enforcement. If someone has dementia, they may not understand that there's been a restraining order issued against them, if such a restraining order was issued, and that might make enforcement really challenging. So next scenario, if a client comes to you and says, I know that my neighbor is doing things to my property, but I don't know if I can prove it. Somebody slashed my tires, a window was broken in my house, and I know it was him, but he won't admit it. What would we think about this scenario?
One person says no, or hard to prove.
Definitely. And I put this in here because I hear this one all the time at my work, people complaining about neighbors doing things, but they don't see the neighbor doing it. We would want to advise the client that it's going to be hard to prove the abuse in court if they're not seeing the neighbor do it. Because the neighbor can show up at court and say, I wasn't doing this. And then the judge isn't going to know who to believe and may deny the restraining order.
And one person suggested the client to get a camera system for their home.
That's a great suggestion also. Sometimes it can help you know who is committing, who is doing the behavior, and then it can also, getting a camera can act as a deterrent. Maybe if people know there's a camera, they might be less inclined to do something like slash your tires. So final scenario, you have a client or someone comes to you and says, my mom is being abused and I want to get a restraining order for her against my sister. My sister is taking my mom's social security checks and my sister is spending that money on herself. What do we think about this one?
One person just said that she has to get permission from her mother to do so. Or will the mom agree to an RO, or if there's any power of attorney involved?
So yes, those are all great things to bring up. So I think it does seem like based on this, maybe financial abuse is happening here, but we've got to wonder, is the daughter able to apply for a restraining order on behalf of her mom? If the mom hasn't set up a power of attorney and made the daughter her agent under that power of attorney, the daughter probably can't apply for an elder abuse restraining order for her mom, and it would need to be the mom who applies for her own restraining order. We would also want to make sure that the mom actually wants a restraining order, and we want to talk to the mom before we do anything, because it is the mom who would be our client, and we need to figure out, what does the mom want here? And I'll note that at my organization, we work with seniors and not family members. So if typically, so if if a daughter or an adult child comes and says, I want protection for my parent, we need to talk to the parent about it. And for anyone who works with seniors, it's really important to talk to the senior themselves and find out, what does the senior want? Because so often what the senior wants can be drowned out by what the adult children or someone else thinks is right for the senior. So a restraining order will not be appropriate for everybody. One option, other legal remedy that someone can take advantage of, is they can hire a private attorney to sue the other person for elder abuse. And private attorneys can have more ability to get money back, especially if there are assets available. And private attorneys often work on contingency, meaning the client may not have to pay or doesn't have to pay upfront for the lawyer's services. And this is typically what I would advise seniors to do if the senior's goal is just to get money back. Because a restraining order is about protecting someone from future abuse. It's not about punishing someone for past abuse or trying to recover money. If it's an eviction that's needed, then the client can hire a private attorney to evict the abuser. And this is what I would recommend, because there's a lot of steps in the eviction process that need to be followed, or the eviction won't work. Someone can file an eviction case themselves with help from the court's self-help center. And they can find the forms for an eviction online and then file the case themselves. And I'll mention one more remedy, and this is not really a legal remedy, but if the person who's being abused isn't going to be able to get a move out order against the abuser, and the two people live together, I often will advise the person being abused that if they are able, they should think about finding new housing. And I know that this is tough in the Bay Area and it's easier said than done. And unfortunately, a lot of people stay in abusive living situations simply because they can't afford to move. But if the person can move, that's something they should consider. So now I want to end with some resources for survivors of elder abuse. The Contra Costa Elder Abuse Prevention Project. All the partners provide different services for survivors of abuse. And sometimes what seniors really want is mental health treatment for their children instead of a restraining order. And so for that, a restraining order cannot order an abuser to go get mental health treatment. So we can advise the senior to call 211 or let them know that there's an assisted outpatient treatment program for people who are really severely mentally ill and resist treatment. And family members can refer to this. Other resources are senior peer counseling, and then the lawyer referral and information service that the County Bar Association runs. People can use that to hire a private attorney. Just a quick recap, and then we can do questions. So elder abuse restraining orders are a way for seniors to be protected from someone who's abusing them physically, emotionally, or financially. There are a lot of resources in Contra Costa County for seniors over 60 years old to get help with restraining orders. And then if we're evaluating whether someone qualifies for a restraining order, first we want to check for the basic requirements, which are someone old enough, is someone 65 or older, or are they a dependent adult? We want to check for acts of abuse and make sure that this person has capacity to actually be seeking help and applying for a restraining order. And Contra Costa Senior Legal Services can help with this. Here's my contact information. Does anyone have questions?
And yes, just we do have one question, but I can answer it. We will be sending out the presentation recording out to everybody after this. And we do have one.
And if someone thinks of questions later, they can always email me or call.
So we do have one question. Can you define a dependent adult?
Yes, so a dependent adult is basically it's someone between the ages of 18 and 64 who either lives 24 hours in an inpatient health facility, so like a nursing home, or it's someone who has physical or mental limitations that make it so that that person can't carry out normal activities on their own. So it's basically people who have one or more serious disabilities or health problems that make it so that person needs help with activities of daily living, like dressing, bathing, getting food, getting medication. And this can be physical limitations, it can be mental limitations, it can be cognitive limitations. So there's no, and it's a functional test. It's not linked to any specific diagnosis. So what this person is able to do in terms of their daily living activities.
Okay, we have another question. If a senior is being abused by their intimate partner, is it best to complete a DVRO or an EARO?
That's a great question. So I would say it depends on what the senior wants. There are more available orders in a domestic violence restraining order than in an elder abuse restraining order. So if the person being abused just wants the abuser to stay away from them, to stop abusing them, to have no contact with them, and to move out, I would say either type of restraining order is fine. They can both do that. If the senior wants the partner to pay spousal support, or if there are issues about control of property or insurance, the domestic violence restraining order can make orders on those things. And so there's a lot more available orders related to things like control of property or insurance, spousal support, in the domestic violence restraining order. So I'd say you'd want to look at what orders are available in the domestic violence restraining order versus the elder abuse restraining order, and then see what it is your client wants. And then they can select the restraining order that is best for them.
Any more questions? Well, looks like that might be it. So again, I think Emily mentioned if anyone had any questions after, they can feel free to email her. But I would like to thank everybody for coming out today. And I hope you enjoyed the great presentation. We're ending 5 minutes early.
Thanks, everyone. If you have questions about any of the different restraining orders, there's also one called a civil harassment restraining order. I'm happy to give more details on the domestic violence or civil harassment restraining orders that I didn't talk so much about. So just feel free to reach out. Thank you, Nick.
Yep. And I will send you the stuff that you asked beforehand in an email.
Thank you. I'll send the PowerPoint.
Okay.